Hi everyone, my name is Deb Kilroy. I'm the CEO of Sisters Inside, and I'm just going to talk to you a bit about protesting. So you're probably wondering, what are your rights to attend a protest? I think it's already been mentioned that Section 22 of the Human Rights Act protects the right of peaceful assembly. It's, however, the Peaceful Assembly Act which legislates in respect to public protests. So Section 5 of that Act protects the right to assemble peacefully with others in a public space. This right is subject only to such restrictions as are necessary and reasonable in a democratic society in the interest of public safety, public order, or the protection of the rights and freedoms of other persons, such as the public's right to enjoy the natural environment and to carry on a business. If you attend a protest, how awesome is that? You're standing up for someone else's rights who are not protected. And you are immune from any civil or criminal liability because of the obstruction of a place. However, the immunity is only granted where the protest is peaceful, authorised public assembly, which is held substantially in accordance with the relevant particulars and conditions of the approval notice of the order. So what are your rights in organising a protest? You know, it's so inspiring for young people to be organising protests in regards to matters that other people are voiceless and invisibilised in our community. So get organising and, you know, we'll be there on the streets marching with you. However, the rights of a protest organiser are the same as an attendee. However, organisers have additional responsibilities, and you need to be aware of those responsibilities to ensure that those rights can be realised. As before, I stated the Peaceful Assembly Act of 1992 grants particular benefits, like legal immunity under Section 6 to authorised public assemblies. Under Section 7, a public assembly is an authorised public assembly if. So there's three parts of this. Notice of intention to hold the assembly has been given, and the notice complies with the Act, and the assembly is taken to have been approved under that piece of legislation, the Act. An organiser of a protest, which is a type of public assembly, must provide the police commissioner and the local authority or council a notice of intention. Such notice needs to be in writing, addressed to those authorities and signed by the actual organiser. Section 9 of the Act outlines the particulars to be included in the notice, such as the date, time, place, which the protest is proposed to be held, expected number of participants, and the purpose of the protest. Sometimes this is difficult, particularly when we march on Invasion Day, and, you know, organisers think that only a few thousand come, but more recently, over the last number of years, tens of thousands of people have been arriving, which is wonderful, to march, to return the rightful ownership back to the traditional owners of this country. A protest is taken to be approved in three scenarios. The first is where notice of permission from the police or local authority has been given to the organiser. Another is where the approval is deemed because the magistrate court has not made an order refusing to authorise the protest, provided the organiser gave their notice of intention not less than 5 business days before the protest. And finally, where the organiser's notice of intention was provided less than 5 business days before the protest. The protest will only be authorised if the magistrate's court has made an order to that effect. A permission notice from the police or local authority for the protest may, following required consultation and agreement, be subject to conditions that concern specific matters, such as public safety or public order. Similarly, any protest authorised through an order of the magistrate court may be subject to conditions. So you need to be aware of the conditions in regards to the protest on the day. So what happens if the police get involved? What happens if the police issue an order to disperse the protest? And what other legal remedies do the police have to infer with the act of activism? Police powers in this state are quite wide, quite broad, and quite horrifying, I would say. Not a big fan of the police powers and how we continue to expand them. But police are governed by the Police Powers and Responsibilities Act, and events that are primarily for the purpose of political advocacy or protest, or are authorised public assemblies under the section of the Peaceful Assembly Act, are not subject to the out of control event powers. However, where a previously authorised protest or unauthorised protest becomes an out of control event, police have a variety of powers under section 53 capital BG of the Police Powers and Responsibilities Act to disperse people associated with the protest. It is an offence to contravene without a reasonable excuse a direction by a police officer in this scenario. It's also an offence to organise an out of control event or cause an event to become out of control. You may also be liable for reasonable costs in relation to the event. Similarly, police cannot use their powers to move on an authorised public assembly under the Peaceful Assembly Act. However, these powers are available for unauthorised protests and allow police to move on people whose behaviour or presence the police officer reasonably expects is or has been causing anxiety to those using public space, interfering with trade or business, or disrupting the peaceful assembly and orderly conduct. Importantly, a police officer must not give a direction to move on that interfered with a person's right of peaceful assembly unless it's reasonably necessary in the interest of public safety or public order or the protection of the rights and freedoms of other person. For example, the rights and freedoms of the public to enjoy the place, or the rights of persons to carry on lawful business in or in association with that place. So police have very broad powers. They also have powers to search and arrest in the suspicion of a crime. One example of a crime that could relate directly to protest is an offence under Section 10 capital A of the Summary Offences Act, to hold an unlawful assembly. An unlawful assembly is where three or more people are together for a common purpose and their conduct would cause a person in the vicinity to reasonably fear that unlawful violence will be used to another person or property. In respects to protests, police may also use their broad powers to take steps reasonably necessary to prevent breaches of peace, rights and offences. There's also been more recently introduced powers following instances of extreme and radical activism to allow police to seize and dispose of dangerous attachment devices. An attachment device generally is something constructed or modified to enable a person to resist being safely removed from a place or separated from a thing. It becomes a dangerous attachment device where it either has been constructed or modified to cause injury to a person or incorporates a dangerous substance or thing. So I remember when the government opened the Southern Queensland Correctional Centre for women, and it was opposed, and a group of young activist women went and lied on the road outside the prison to stop the prison vans bringing women into that prison. And the plan was originally to put their arms into concrete, into barrels, so that a person could not move those barrels. They were arrested. They did stop a van. It did ensure media where we could raise the issues that opening a new prison for women would just mean that more and more women, particularly Aboriginal and Torres Strait Islander women, would be incarcerated and the numbers of imprisonment increased. And we were right, because that's actually what's happened. However, we took to the streets, there was a protest, and even though we didn't get the result, the community became more aware of what we were advocating for. It is a summary offence to use dangerous attachment device to unreasonably interfere with the ordinary operation of transport infrastructure, prevent a person entering or leaving a place of business, or from the ordinary operation of plant or equipment. So what should you do if you believe your rights have been violated? Great question. Depending on how your rights may have been violated, you have several reporting options. Under the Criminal and Corruption Act, 2001, here in Queensland, police are subject to external oversight in relation to corrupt conduct and police misconduct. This includes serious allegations against police such as assault or excessive use of force. You can make a complaint directly through the Crime and Corruption Commission or through the Queensland Police Service, who are obliged to notify the CCC of corruption allegations. If your complaint is less serious, you may make a complaint to your local police station or the Ethical Standards Command within the Queensland Police Service, which may investigate the complaint internally. Alternatively, you may make a complaint to the Queensland Ombudsman through the Ombudsman's Act, and it can only investigate some complaints about administrative actions taken by the Queensland Police Service. But we all know one of the biggest issues that activists like myself have been arguing is to end police investigating police. But these are the only legal avenues to have your complaints investigated at this time until the government changes the law and stop allowing police investigating themselves. So what do you need to know to get yourself out of trouble? Staying out of trouble is often the best way to get out of trouble. You can do this by knowing your rights and responsibilities under the law, many of which have been discussed already. It's important to highlight that police operate with a large amount of discretion, huge amount of discretion. And it's often in your best interest to be cooperative in any dealings with them. For example, police have the discretion to either make an arrest where you are taken into custody or issue a notice of appear in court on a particular day. In such a scenario, you may ask for the notice and the police officer may be more likely to exercise that discretion where you have been cooperative. However, if matters do escalate, and you are charged with an offence, you may seek free legal advice through legal aid or a community legal centre, through the Aboriginal and Torres Strait Islander Legal Centre if you're a First Nations person, or engage private criminal lawyers. Remember that you have the general right to remain silent, and this should be exercised until you have the opportunity to talk to a lawyer. Don't take notice of all those crime shows on television where people who are arrested think they're going to talk themselves out of an offence. You will never talk yourself out of an offence. Get a lawyer and remain silent until you speak to that lawyer. So those of you who are passionate about extreme activism, this excites me because sometimes we need in our activism to be more extreme to bring attention to the issues for the most vulnerable members in our community. And activism plays an important part in our democratic society by allowing individuals to play a more direct role in social and political change. Students who are passionate about activism should be aware of your rights, absolutely be aware of your rights, and feel confident to exercise those rights and in ways that do not impinge on the rights of others. Those who are seeking to engage in the more extreme activism should be aware of the potential consequences due to that activism, and particularly in extreme unlawful activism. Further, you should consider whether the most extreme types of activism are really the most effective. And that's about weighing up the pros and cons of your actions and what you're going to take to the street and how you're going to bring attention to the issues. So good luck, and I look forward to seeing you on the streets. Come and say hello. Okay, bye.